$1 million verdict against someone who has only $100,000 worth of coverage. But that constraint doesn't exist with a deep pocket defendant such as the state. And in that case, the stakes go up considerably, and the ante is usually non-economic damages, because those are the big unknown in the case. That as counsel Mr. Mays mentioned, a wide variety of factors can influence the outcome on that particular issue. With economic damages, at least you know somewhat in advance, and you have an experience with the experts and other similar cases to predict where you're going to come out with on the economic loss, but it's extremely difficult to do it on non-economics, and if you are wrong, you can be really wrong. And that is the fear that I think the legislature was reacting to when parties who have this risk exposure came to them and said, we cannot manage this because the whole system is driven by the fear of this huge award. Now, the appellant's response, I understand it to be, to that point, to be it's unfair to penalize the most severely injured because it is those persons whose awards you will cap. I would point out first that by their own admission, the cap does not affect the vast majority of cases. The cap provides a range that is now in excess of $600,000 for an infant for non-economic damages, and does not affect at all the myriad of economic damages which can be recovered.
Do you have any idea how large that class is that's being excluded for the severely injured, percentage-wise or dollar-wise or any way?
No, I don't.
Do you have any?
I have no way of saying that, because I believe
Plaintiffs' briefs indicate there's 5 or 6 cases of that nature. Is it something relatively small, under 5%, or is it half? Or?
I believe you cannot say, because you cannot predict with any kind of significance what case is going to fall into that range or not until it matures.
But you've had 2 years' experience now. How large is the class?
Well, our experience is still with cases which were under the old law, and I don't believe we have had an experience with a catastrophic injury case.
Whether it's accurate or not, what is your experience? What percentage is in this disabled category?
I'm sorry, Justice Dorr, I'm really unable to answer that, because I would have to reflect on the ages of all the plaintiffs in the cases that brought in large non-economic awards.
The really disabled people that would be cut off, like this case. How many cases are there like this?
Well, this of course is a death case, a death of an elderly, but let's assume a wage earner, with an award that would be on the high end, I think, of anything that would be reasonably predictable in Western Washington. So it seems to me that this case probably, falls into some percentage that. Well, I'm sorry. If I answer that, I'm going to regret the answer I give, because I think the point that I should be making is that you cannot really say with precision who is in this class and who isn't.
Well, you've told us about your 6 attorneys before and up to 28 attorneys, so you have some idea of that. Do you have any idea of how large this class is of severely injured people?
No.
But have you cut any attorneys down since the bill went through?
No. But we are not seeing as yet cases coming to trial. We've had 2 years, and if you look at a 3-year span for most cases to work their way to trial, we have not had a large number of catastrophic injury cases come to trial under the
Would you say that in the last 2 years has been insignificant?
The
last 2 years has the class been insignificant for severely injured people that would go over the cap?
I would say in terms of numbers, perhaps. In terms of effect, no, because when you deal with a case which has, or at least it's thought to have the potential to go over, one of those cases can erase 10 others that you've got a result that you could predict.
In other words, the thrust of your argument in it is very helpful on settlements, as distinguished from writing off the cases themselves.
Certainly this act promotes settlement in the sense that it makes the quantum of non-economic damages, which you then add on top of the known quantity of economics, a predictable factor. And it takes out a big unknown which people are prone to gamble on.
Counsel, maybe you can answer this again. may not be within your division's authority. I find it a little peculiar that that you're defending a statute that is premised by its own terms upon an insurance crisis, which in turn is premised upon the insurance industry. And you're also at the same time a party to a lawsuit that says this was all a great conspiracy, that it was one of the greatest consumer frauds ever put forth.
Well, having anticipated the question, I have had a chance to consult with our antitrust attorneys, and I believe I can answer it. First of all, I think this notion that the legislature is hoodwinked by the insurance industry is ridiculous on its face. Even if you take into account the new evidence which has emerged in the lawsuits filed by the several attorneys general in recent months, the legislature was unquestionably aware of the claim, which was made by these same parties, that they were being stampeded into something and that this insurance crisis was really the result of mismanagement and market manipulation. Secondly, the court needs to keep in mind that the lawsuit which was filed by our state alleges a conspiracy amongst 4 domestic insurers and 2 reinsurers, along with an insurance service organization, to restrict the availability of one line and to substitute an occurrence-based policy with a claims-made policy. The quotations which the plaintiffs have given you from the press release from Attorney General Maddox in Texas refer to his own lawsuit filed in the state of Texas, not the lawsuit to which we are a party.
Your time
My
has
time is up. Thank you.
expired.
May it please the court, my name is Stephen Johnson. I'm here representing several of the defendants who were present at the trial court level. I may have some answers to some of the points that were raised, so I'll step out of my prepared comments for a second and try and respond to a couple of them. In terms of how many claimants are affected, there is material in our brief, and there was material before the legislature in terms of the tort policy working group that indicates that in round numbers, it's a comparatively small number of claims, but the amount of the awards constitute a disproportionate amount of the total awards paid. The working group found that in cases where the award of non-economic damages exceeded $100,000, this element of damages comprised on the average 80% of the total award. As to medical malpractice claims, the report found that only 3 to 6% of such claims involved non-economic compensation over $100,000. But those cases with non-economic damages exceeding $100,000 accounted for approximately half of all medical malpractice damage awarded. The other point that I'd like to note on that score is that it's very difficult to define, not only because of settlements, but because of the phenomenon that I think the legislature was addressing, what people fall into this class. The asbestos litigation itself provides a very good example of this. In 2 other cases, tried in the past year with substantially identical facts. There was the same plaintiff's firm, the same defense firm, same disease, many of the same experts testified, most of the same companies as defendants. One was the Falk case, the other one was the Foster case. Those cases went to trial in the face of extremely large settlement offers. They went to trial with people who were dying of cancer during the course of the trial. Those 2 cases resulted in defense verdicts. I presume that they went to trial on the basis of the plaintiff's counsel and his client's determination that there was a good chance that a jury might award many times the amount that was being offered in settlement. However, the amount in the Falk case, for example, was over $500,000. So it's very difficult to define who is in this class because of the very ill noted by the Tort Reform Policy Working Group. You are encouraging people to go roll the dice here in hopes of racking up a very large recovery on an emotional basis in an area of damages that has no standards. And that doesn't always work. And within the past year, as I say, in 3 identical cases, one of those cases was the case which is presently before the court. The other 2 cases resulted in outright defense verdicts. With respect to the issue of whether life has changed at the Attorney General level or elsewhere, I would note that this case was accelerated for trial. The only cases that our office has seen on a base of many, many asbestos cases that come within the province of the new act are cases that are accelerated for trial because of the health of the claimant. The other cases will not be going through the system, and we don't expect to have any results in connection with them for several years. So there's no real base of experience yet to tell what impact this is having.
What was the failure of the remittitor-additor approach that brought forth the Tort Reform Act? Why did that not work?
In my opinion, Justice Callow, the problem with remittitor and additor is that it couples sort of the worst of both worlds. It couples an item of damages which is addressed to the jury for fact-finding with a jury instruction that expressly tells them that there's no standards by which to judge it, with an element of judicial deference on the other hand that says that we won't alter or adjust any jury verdicts unless the outcome shocks the conscience of the court. When you have a decision made by a jury, presumably according to their most reasonable lights in the first place, coupled with a decision by the court to see if its conscience has been shocked, it does not provide any realistic kind of limit on the parameters of what's going on here. In that regard, I would like to note briefly that I think that this court is not limited by its own standards of review to the statements in the legislative statement of purpose and intent here. I would cite the court particularly to its decision in Conklin versus Shinpocket back in December of 1986. When reciting the standard of legislative deference, the court noted that the legislature has broad discretion in establishing classifications in social and economic legislation, and that a classification will be upheld if any state of facts may reasonably be conceived to substantiate it. So I don't think that the limit of our inquiry here is so much constricted by the legislature's statement of intent as it is by the operative effect of the statute on its terms and the impact that it has based on the experience of the courts. If I can find my notes here. Turning briefly to the right to jury trial argument, I would like to emphasize very strongly a point that I don't think has been emphasized. The line between the right to jury trial and what does and does not invade it, I think, is a comparatively clear one, and it has not been addressed here this morning as clearly as I think it is. The line is between the jury's right to determine the facts in a case and the operative law and consequences that give rise to a cause of action and the results or remedies that will flow from those facts. In particular, the Oregon case, the Molodai case that was quoted by Mr. Rutzik, is clearly a taking away of this fact-finding power from the jury. The court or the legislation sought to substitute a formal appraisal procedure for appraisal by a jury. That's a clear infringement on the right of the jury to find facts. The issue of what causes of action exist, what elements or facts will give rise to those causes of action, what remedies will flow from those causes of action, is something that has never been in the province of the jury. It has always been in the province of the court and the legislature under their power to determine issues of law. And this court and all other courts and the legislature and all other legislature tinker with those things endlessly, constantly defining or finding new ramifications, new rights, new remedies, new limits, new elements, and so forth. And that's entirely proper. What is involved in this statute is a limitation in the remedies area. It does not intrude on the jury's ability to find facts one bit. It just says that when the jury's finding a fact and valuation of a case exceeds a certain amount, then it will not be awarded as a remedy. And plaintiff's presumption that the remedy must equal the finding of fact by the jury has no other counterpart in the law. And the numerous situations cited by Mr. Mays, I think, are all on point here.
Well, do you put any significance on the cap itself? In other words, you have 15-year minimum life expectancy, and you say that's reasonable. I think you're arguing from that viewpoint. One or two said 2 years. Shall be no more than 2 years life expectancy, which would really reduce it down to most cases. My question is, does the amount of the cap have anything to do with the constitutionality?
I think this strays, well, I guess it covers both issues. I do not think that it does, in the sense that plaintiffs have basically conceded here that any cap, per their arguments, is unconstitutional.
I asked the same question with the high cap.
Yes.
5 million, whether you would argue the same.
Yes, I would argue exactly the same, Your Honor. I think that the Washington statute is, if anything, more compassionate in the sense that it tries to militate against the inherently unfair or inequitable results that would result from a flat cap.
In other words, that's the exclusive determination of the legislature. The court shouldn't be concerned with a high cap or a real low cap. That's not within their jurisdiction.
Well, I think within the modes of analysis here, that's true, Your Honor. I'm not here to suggest that this court doesn't have the power to determine the constitutionality of these issues, but I think the court has a fine tradition and long-standing one that has been restated recently this year in several decisions, that it respects the separation of powers, and so long as the legislature had a rational basis for making the determinations and line drawing that it undertook, that this court is not going to interfere with that. And within that context, I do not think that the examples that you cited would make a significant difference, although I am sure that we can come up with examples that would be so egregious as to call into effect one constitutional principle or another, but I certainly don't think that these do.
Well, if we put it down to 2 years life expectancy, it would be extremely small. It probably would affect 80% of the, I don't know 80%, but at least 50% of the cases if we reduced it down to that. Wouldn't you agree with that?
I would agree, but it would, we're talking about a speculative piece of legislation here. I would want to respond based on what impact that had and where the legislature set the numbers. If that resulted in reducing all cases to $2,000 or $3,000 on non-economic damages, I think that the debate might be more pointed. But I still think that the legislature and the courts, as they have done repeatedly, have the right to define what remedies shall flow and what causes of action shall flow from a given set of facts. Non-economic damages, this court has already recognized, are not a vested right. And presumably, the legislature and the courts, as appropriate, have the power to influence that.
Maybe I've already asked this question, but I'm trying to clarify it for myself. You're saying that the cap itself, whether it's high or low, no matter how low or how high, is not a matter of constitutional concern in this argument.
I don't know that I'm comfortable just saying that completely in the abstract and holding it up for whatever targeted examples one might reach. I think there is very broad latitude under the separation of powers doctrine, under the minimal scrutiny doctrine, which I think is just an enactment of the separation of powers doctrine, within which a legislature can operate in this area.
Well, let me put it this way. Do you think this court has jurisdiction perhaps to up your, just like we have a judge in a trial has a right to put an addendum of extra money on, that we have a right to say, well, we don't think that cap is adequate or fair, but we think that maybe 4 times that would be fair. Do we have that right?
Respectfully, I don't believe that you do have that right, Your Honor. I think that in this context, it is the duty of the court, as Justice Utter wrote in, I believe, the Aetna Life opinion in years gone by, it is the duty of the court to determine whether this passes constitutional muster, whether the people in the exercise of their right to determine their own laws have run afoul of the Constitution. In the area of additor and remittitor, we're talking about judge-made law. The court, just as the legislature might in another context, has defined the remedies and the restrictions on the jury's power to adjudicate things, and in that context, I think this court would have that power, but that's not the question before the court here. I would like to briefly touch on equal protection with the time that is remaining to me. And in terms of the issues which we have reserved for cross-appeal, in the unhappy event that the court were to rule differently on the main appeal than we hope and think that it should, I would refer the court to those, and I will be happy to finish what I'm doing quickly, and if there are any questions in terms of our briefing material, I'll try and field those. On equal protection, first of all, I would like to note that Mr. Stritmatter posed some very dramatic examples to this court, very compelling examples. Unfortunately, they have absolutely nothing to do with the law that's before the court here. Mr. Stritmatter spoke in terms of the rights of people to have support, the rights of people to have medical care and so forth for their injuries. None of that is affected in any way by the statute. The statute gives a dollar-for-dollar recovery as to all economic damages. The only thing the statute does is to place a limitation on the high-end range of where non-economic damages can go. So I think that however compelling those examples may have been, they are entirely off point here. I think the use of the Hunter case is similarly inapposite here. The Hunter case was dealing with a situation in which the court found that due to the claims statute, claims were being cut off altogether, and the people were being left with no right or remedy at all. This case is not that case, nor are the cases within the purview of the statute. People coming within the purview of the statute have the right to recover every dollar of economic loss, and economic loss, as the court knows from reading the statute, is quite expansively defined in terms of any loss of income or anything that could even be characterized as a financial loss. Excuse me. And I don't think Hunter and Hunter's language about the nature of the rights here is on point in this case. If you had to define the right, I think you'd have to define it so narrowly as personal injury claimants who have the good fortune to bring in awards over a set amount, not just anybody who's injured. In terms of the invitation to this court to adopt intermediate scrutiny, I think this court has wisely already restricted the scope of the Phelan case in its subsequent decisions. I think there are numerous troubles with the Phelan case, and I think they were remarked on by Judge
Which
Maddox.
was Phelan, counsel?
Phelan was the case in which the court
what were the
was
facts?
dealing... Pardon?
What were the facts?
My recollection, Your Honor, is that the facts had to do with a pre-sentence credit program for time served. The court's decision spoke in terms of the intermediate standard of review. I think, with the yellow light on, Judge Maddox quite eloquently below touched on the problems with that approach. It offers no presumptions for the court, such as the classifications of strict scrutiny and minimal scrutiny do. And it is, I think, a very troublesome hazing of the important lines between judicial input and legislative enactment. Plaintiffs have conceded that strict scrutiny is not appropriate here. At least I haven't heard them make that argument, and I don't think it could properly be made. Under the rational basis test, I have already mentioned that I think that the legislature's sliding scale is a positive thing here and an attempt to discriminate less, not more, with classifications that of their very necessity must draw lines. I think that it is in the common experience of anybody working in the court system that the most compelling cases by far are cases dealing with with permanent injury, and that those cases almost invariably impact people of a younger age who are forced to live with those injuries throughout their lives disproportionately to people of an older age. And I think that is the clear intent of the statute, and I think it is more than passes the rational basis test. On the issue of Oregon law, again, I believe that our supplemental brief to the court adequately covers those matters. If there are any questions on any of these matters, I'd be happy to take them at this time. Other than that, I would refer the court to our briefing on the cross-appeal issues and on the supplemental brief.
Thank you, Mr. Johnson.
Thank you very much.
Hi, I'd like to touch briefly on the jury trial rebuttal, and Paul Stritmatter will deal with the equal protection issue. The jury trial analysis is a historical analysis that has been this court's teachings from the very beginning. The issue is, what was the right to a jury trial at the time the Washington Constitution was adopted? As I said in my brief, and I'll say it again, at the time the Washington Constitution was adopted, a jury's verdict as to damages was effectuated unless, based on the particular facts of the case, the trial judge either thought it was based on passion or prejudice, or the amount was beyond a reasonable setting. The implication, not the implication, the statement that the right to a jury trial is preserved if the jury can go through the charade of making a decision, but nothing happens to it, simply makes no sense and is directly contrary to what this court said in the Strasburg case, where this court at page 116 said Now this right of trial by jury, which our Constitution declares shall remain inviolate, must mean something more than the preservation of the mere form of trial by jury. It is hard to imagine a clearer example of a mere form of trial by jury than to have the jury, as is the case here, do it, but have no attention paid to it. And in fact, a point that the question was asked, is this a form of guidance, or might this be viewed as a form of guidance to the jury? The statute, by its terms, precludes the judge from telling the jury. And it's right in the statute. You don't tell the jury that their decision is meaningless. Far from being an attempt to guide the jury, it's really an attempt to keep them in the dark. It's almost to fool them. You make your decision, and we won't tell you that your decision has no impact. That is not remotely the way a right to trial by jury existed in the past.
But didn't they in territorial times, or in early times in this state, wasn't the right of remittance something that it isn't now? In other words, in the Bingaman case, where the woman out of Grays Harbor County, where the woman died as a result of a botched up delivery, where we reversed the Court of Appeals, which had in effect upheld a remitter. And because I can't remember any remitters that have been upheld on appeal. And I mentioned Bingaman because I wrote it for, as I recall, a unanimous court. So when you talk about remitter being a check on this, is it really? It may have been once, but is it now?
Well, I'd say two things. One is, I think literally the statute, which is currently in effect, was in effect at the same time. Now, obviously, times change and attitudes change, and there's been a lot of inflation since 1889, and so figures which would have seemed incredible at that time are more commonplace. I would say that I don't know. I mean, you all probably know better than I to what extent
Well,
the
it's
times have
as
changed.
counsel on the other side mentioned, the court refuses to touch those unless their conscience is shocked. And in that case, the facts were so grievous, our conscience was not shocked by the size of the
I think rightly so. I think the point I'd want to make is the statute permits, and nothing that I'm saying suggests what this court or the
You see,
trial
all I
courts-
was saying, counsel, is I'm not sure remitter is the check now that it was then. What you're saying is you believe we have the same statute, which
and I
maybe
think
so, I don't
and
know.
it could be the check. In other words, the statute's the same. Obviously, it's susceptible to determination. The availability is there to make, and this is the crucial thing, an individualized determination. Bingaman provides a good example. I remember the facts; they were just terrible. In another case, the same amount without those kind of facts, you react appropriately. Constitutionally, that's well within this court's decision. There's no constitutional impediments to the way that statute is to be applied. I mean, it's the same standard. And so it is there, and this court or a trial court can use it as appropriate, and that's entirely constitutional. That's not what's done here. The legislative history of this one, to the extent it's there, really shows two things, if I might. One is three things. One is it shows, and we quoted it, it shows a distrust of the jury. It shows there is no reflection, parenthetically, no idea that anybody even considered the effect of remitter in the thing. And interestingly enough, it shows that the lawyers who talked in the legislative history said this is unconstitutional.
You used 5 minutes.
This violates.
Of course, that was one side of it. I mean, and it was the losing side of it. With due respect.
But even the winning side, basically, and I think a fair reading of it is saying we can't trust the jury. And they may feel that. They may feel that. I'm not suggesting they don't feel that. But the Constitution is there so that those feelings can't be effectuated. I'll take a tiny bit of Mr. Stritmatter's time. Just one last point. The issue was raised, well, in a number of cases, this court has or could eliminate trial by jury entirely. Therefore, it follows that it can be limited. And a good summation of that issue is contained in Professor Troutman's law review article in about 1959 or 1960, which I think explains the distinction. He says, one might summarize then by saying that the constitutional provision relating to jury trials does not guarantee that a cause of action which existed at the time of the Constitution's adoption will be continued. It only guarantees that if it is continued, a right to jury trial incident thereto will continue. That's the facts here. Nobody has, and there's no law which takes it away. There's a jury trial, and therefore there's a cause of action at law, and therefore the constitutional provisions that I've talked about continue to apply.
It's been suggested that this court should presume the statute is constitutional and that we have the burden of proving beyond a reasonable doubt that it is unconstitutional. That is not the case. Article 1, Section 29 of our Constitution declares that the provisions of the Constitution are mandatory. The application of a presumption of constitutionality hampers this court's duty to pass on constitutionality of statutes under the separation of powers doctrine. It grants too much deference to the legislature and almost places the actions above the Constitution. In fact, in order to overcome this oft-stated presumption, the federal courts have created a contrary presumption that statutes involving fundamental rights or suspect classes are presumed unconstitutional. So it's the weight of any presumption, the weight of any presumption, I should say, depends upon the nature of the statute that's being challenged and the type of rights that are involved. We are dealing in this case with both fundamental rights and substantial property rights as recognized by this court. And both of those destroy any presumption of constitutionality, and I suggest maybe even create a presumption of unconstitutionality. Certainly under the heightened scrutiny test, there is no presumption of unconstitutionality. It's been suggested that this statute would pass a rational basis test, and I suggest even if that test were applied, that isn't true. It is not rational to limit the damages of a person who's physically injured because she or he has a spouse or children or other dependents who may also have suffered a loss, and permit a larger recovery for one who has no such family members, when there's no record whatsoever to show that the limit on awards for consortium will affect the availability and affordability of insurance. Likewise, it's not rational to limit the permanent injury damages of one person by statute because of age, and not the permanent injury damages of another when age has already been taken into account in setting damages by the jury. Or alternatively, it's not rational to limit the non-permanent injury damages of one person by statute because of age, and not the non-permanent injury damages of another. That's age discrimination when the jury has already taken age into consideration. It's suggested that this statute would promote settlement. It will do exactly the opposite. The likelihood of settlement will diminish when one side runs no risk going to trial. If there's a limit on the amount of their responsibility, then they'll go to trial. They're certainly not going to pay that limit. They might as well go to trial and see if a result is less than that. With insurance companies, only when we have the specter of bad faith against them may there be a settlement, but there wouldn't be that element here. Promoting settlements by coercing only one side, as this statute does, is not a legitimate means to this goal. In conclusion, Your Honors, this statute is discriminatory. This statute violates fundamental rights of the citizens of the state of Washington. This statute takes away our rights to have the citizens of the state decide these important issues from the jury box. This statute is unconstitutional, and it is our belief that it is your responsibility to strike it down. Thank you very much.
Thank you, Mr. Stritmatter. Court will be at recess until 1:30.
All rise. recess.